So we've been speaking a lot recently about how to sell your business, how to get your business to be sale ready, and what from a due diligence perspective a buyer will be looking at when they decide whether or not to proceed with purchasing your business. But what does the legal documentation side look like? Well, from a seller's perspective, it's very, very common that the buyer would draft the majority of the documentation. So the main document you're going to enter into is a sale and purchase agreement. That's where you agree to sell and the buyer agrees to buy your shares in the company for whatever price you determine and agree between the two of you is what you're going to pay. Now that pricing might be all upfront, it might be a bit upfront, some deferred, some might be performance based, whatever it is, that will be covered in that agreement. And that agreement will also include you providing certain warranties, certain promises to the buyer about things that have happened in the past with the company. So for instance, there haven't been any legal disputes, we haven't had any employee issues, etc, etc. There's a load of them that you will provide. It's our job as lawyers to make sure that you are properly protected when you sign that agreement. You don't want unlimited liability. You don't want them to be able to sue you for years and years after you sell. So that's our job to ensure that that isn't the case. The next document to think about is called a disclosure letter. That is one that us as sellers would frequently draft, and that is where, relative to the warranties that I mentioned, so all those promises you're making, you're going to note any exceptions. So there might be a thing within the SPA, the sale and purchase agreement, which says there have been no legal disputes against the company. This is your opportunity in the disclosure letter to say there actually was a legal dispute 4 years ago, it was dealt with, we settled out of court, etc, etc. Anything you put in the disclosure letter will mean that you are not able to be sued for that because you properly disclosed that to the buyer. These are the two main documents you want to think about. Now, depending on the structure of their deal, there might be other documents. If you are retaining a percentage ownership in the business, for instance, if you're staying on as a 10% shareholder for a while, there might be a shareholders agreement in place. If you're staying on to provide some consultancy or transition services to the buyer, there might be a consultancy agreement in place. So a lot of the time will just depend on the nature of the deal. Then we'll have our ancillary documents. There's a load of these. They're not really negotiated very much because they're quite straightforward, but we do need them. So it's things like your stock transfer forms that physically moves the shares from you to the buyer, resignation letters, board minutes, share certificates, persons with significant control resignations. All of these are small documents, but you'll see loads of them, and they all need to be signed in order to get to completion. Once these documents are all agreed and signed, that's when we can proceed to transfer the funds across so that you'll receive them. You have then sold your business, everything's updated, the buyer deals with paying stamp duty and telling HMRC, and you're done. That's your business sold. If you're thinking of selling your business and you'd like to chat to a friendly face about what that might involve, what the costs for legal support are, and how we do things a little bit differently, then drop me a message or comment below this video and I'd love to have a chat with you about that.